Case set for argument is State of Ohio versus Frank Murphy. The state has waived its oral argument in this case, so we will hear just from the appellant, Frank Murphy's attorney, Mr. Contreras. You'll have 15 minutes to present your argument. We've read the briefs and are ready to proceed. If you are, please take note of the clock on the wall as well. That'll help you keep track of the time. And keep your voice up, stay at the podium as we do record these.
Very good. Will do.
You may proceed.
Thank you, Jim. May it please the court. Obviously, you just mentioned you had read all of the briefs, so that's much appreciated in advance. Sometimes there are little post-it notes. Somebody wants to hear the story first and read the law later. So I appreciate you putting in the time in advance.
Sure.
As I was preparing for this earlier this week, something came to mind. I have a 10-year-old who's in 4th grade. He's in a math class. He's got this orders of operation question, right? He's supposed to do everything in the parentheses first, then multiplication, division, addition, subtraction, everything left to right. We're all lawyers. Math wasn't our strong suit. That's why we're lawyers. But it reminded me that we know something about the order of operations and what is supposed to happen first and what is supposed to happen next. And I think that that's really the story in this case here. We have, under the facts, Frank Murphy is in a wheelchair at 3 in the morning in the middle of the street in an area that Officer Pasternak claims to know or believe is a high drug activity area. Now, he's not witnessed doing anything illegal other than potentially jaywalking. And in fact, that's what Officer Pasternak says, okay, we're going to stop him for jaywalking. So they stop him. They start having a conversation with him. A couple minutes go by through this investigation. And there's no Terry pat-down, there's no concern for officer safety. Officer Pasternak, in fact, in his testimony at the suppression hearing says, I wasn't concerned. My investigation was not being impeded by fears for officer safety. I'm just asking this guy questions. And meanwhile, Mr. Murphy is there. He's in his wheelchair. He's not going anywhere. He's waving his hands around. He's gesticulating. He's on his phone in the beginning. And
Well, they knew he was known to carry a gun. Did they actually see a weapon on
So
him?
they saw nothing. They saw nothing. The alleged knowledge of his prior criminal activity or that he was a drug dealer and that he carried a weapon was based on prior arrestees, not Mr. Murphy. Other people who had said something about him and potentially some calls that had been made about where Mr. Murphy lived.
How about the fact that it was, this was at 3 in the morning, right?
This was 3 in the morning.
Yeah, high drug area.
High drug area. You know, but I mean, by the same token, there are families who live on that street. You know, high drug area doesn't mean that everybody's doing drugs. And look, I'll step back from my role as a defense attorney for a second.
Well, I guess I'm asking, is that all that the officer had to go on?
That's all that the officer had. I mean, and this is it. And I understand that, when you look at the conclusion of all of this, what they end up finding and all of that, I understand. Nobody wants to suppress good evidence, or I shouldn't say good evidence, evidence of criminal activity. But there's a way we're supposed to do these things. And to exactly your point, Judge Teodosio, that is, you need some kind of at least reasonable suspicion, right? There has to be something to justify a stop. Now there's jaywalking. Fortunately for Mr. Murphy, Ohio law says that jaywalking is a minor misdemeanor. Minor misdemeanors may not be placed under custodial arrest. So absent any other reason for the officers to search him, absent some type of reasonable suspicion of actual criminal activity going on, and yes, there are indicators, 3 in the morning, high drug area, but that's it. Nobody witnessed him doing anything illegal other than crossing a street where he wasn't supposed to. So based on that, and this is where I get back to my order of operations analogy, they come up to him and they ask him, okay, what are you doing out now? Can I search you? They're asking for consent to search. And Mr. Murphy says, no, I don't want you to search me. I refuse to search. Then,
Have they already given them a citation for jaywalking?
they have not actually. He invited them to do so. He said, okay, so you got me for jaywalking, please write me a ticket. And they wouldn't. They kept going.
He's basically saying, write me a ticket, let me be out of my way.
Because that's the totality of the illegality that was going on when they stopped him. He's in the middle of the street, in a wheelchair, jaywalking. Okay, we're in a crosswalk, we weren't supposed to be there. Write me a ticket, let me go. It's not so different from a car gets pulled over, write me the speeding ticket, let me go, absent anything else. And the law says, under State v. Brown and under Revised Code 293526, that minor misdemeanors cannot be custodially arrested. You write the citation, you let them go.
Did they at some point decide we're gonna write the citation?
Well, so things progressed and snowballed, and they never ended up writing him a citation for jaywalking, at least not to my knowledge. What happened is they asked him for this consent to search, and he refused. He said, write me a ticket, you can't search me. At that point, and again, remember, Officer Pasternak, through all of this, said he was never in fear of his own safety, it was never impeding his investigation. But at that point, they said, oh, well, no, now I'm going to do a Terry pat-down on you, because now I'm worried. I've been talking to you for 3 minutes, I asked you for consent to search.
Was he the only officer on the scene?
No, there was a second officer there as well. And I think another car pulled up in addition.
I'm assuming he didn't say anything different. Of course.
To
Safety
anybody else?
concerns, yeah.
No, there was no concern. I mean, there was no concern. And in fact, he admitted on the stand during testimony that was being offered at the suppression hearing that he performed and asked for consent to search and performed the Terry search to find evidence of a crime. That's not what that's for, right? We all know that the standards for Terry is that there has to be a reasonable, articulable suspicion of criminal activity. A mere hunch is not enough. So hearing from other arrestees that this is a guy who carries a gun and sells drugs, well, that's a hunch. You've got nothing to go on in this particular stop. And there has to be a prudent standard, a reasonably prudent person standard for safety concern. And he repeated that there was no concern for his safety at the time of this stop. So the Terry search itself, especially after having asked for consent, was obviously pretextual to try to look for some type of evidence of a crime, some type of criminal activity. Ultimately, that's what ends up happening is they find a lot of marijuana on them, they find some cocaine, they find a gun, they find some cash. And as I was saying before, I get it. Stepping back out of my defense attorney role, right? We don't want to put away evidence that we find. We don't want to suppress that, but that is the proper sanction when the state acts improperly. And that's the situation that we have here. Every one of these pretextual stops, I'm stopping you for jaywalking because I want to find out what drugs you have in your bag, erodes all of our Fourth Amendment rights. And these are things that we hold sacrosanct, we hold dear, and they're the foundational elements that build up our entire constitutional rights. And so here we're faced with exactly that situation. Now, there have been a couple of cases that have come before that are analogous to these. You said you read the briefs, which I appreciate again.
Counsel, I have a question.
Absolutely.
Under Terry,
Yes.
is having knowledge that a person might be carrying a weapon sufficient to want to do a pat-down? Or does the officer have to have some justifiable fear?
There needs to be an articulable suspicion. So,
Suspicion of which one? The weapon or
well,
fear?
Of fear. There needs to be concern for safety. An articulable suspicion that rises to the level of not necessarily probable cause, not quite that far, but a reasonable suspicion that he might have something that is going to endanger me or those around me. And in this situation, I think that standard has not been met because on the stand, the officer said he was not concerned for his safety. It would be different if he took the knowledge that he had previously, right? That somebody told him this guy carries a gun, you better watch out. And he knew who he was. When he pulled up, they said, hey, you Frank from Nome Street? And Mr. Murphy goes, yeah, that's me. So they knew who he was. They had this before. And even still, he said, I'm not worried. I'm not scared for my safety. This is not impeding my investigation. So I appreciate the question because it highlights the fact that, number one, there's no probable cause, so we didn't rise to that level, but even the reasonable suspicion of criminal activity, or something that rises to the level of reasonable suspicion to fear for officer safety, that wasn't even met because the officer himself dispelled any of the contention that that fear existed.
So the trial judge said the officer testified that because they knew your client was known to carry a weapon and sell drugs, they asked for consent to search his person. Later on, the judge said that was sufficient for the Terry pat down. You're saying the judge then basically misapplied the law in that respect.
Well, I believe that's why we're here, Judge.
Okay.
Absolutely.
Sometimes,
You know, and
sometimes I'm not certain why we're here, but at least we're on the same page there.
I can appreciate that.
Okay.
You know, and I mean, look, I appreciate Judge Croce, absolutely. I will say though that in this case, where the officer's testimony flies in the face of, you know, of that, it doesn't match the Terry search purpose. If Mr. Murphy had consented to the search, you know, that's why they asked for consent. We know who this guy is, we know what he does, we know what he might have on him, I'm gonna ask to search. But when Mr. Murphy said, no, you can't search me, and there was no other articulable reason to search him, officer safety, evidence of criminal activity, any of those, that's where it should have ended. They should have written him the ticket for jaywalking and sent him on his way. Absolutely. The briefs in this case were obviously fairly short. The state, who is not here, I think totaled 6 pages. Mine were much longer. So there's not a whole lot more to go through here. I could certainly highlight the cases that were highlighted in the briefs, or if the court prefers to take that under advisement and read the briefs, I don't necessarily want to be repetitive. So if there are no further questions, I would.
Appreciate your commission. Judge Gallant. All right, thank you very much for your presentation today. The court will also take this matter under advisement for decision in due course. The clerk of courts will certainly mail a copy of this decision to you once it is released. And the opinions are also posted on the Supreme Court of Ohio's website. Thank you again very much for the arguments.
Absolutely, appreciate the question.